reflected in the flyer, we tried to give you an overview of what we hope to cover. And so let's get started. Attorney Johnson, you ready to tell us about just a rough overview of this process?
Okay, thank you, Professor. I will also say that Professor Neville-Ewell was also my professor in law school, so thank you so much. Thank you for putting this together with the Young Lawyers Association. This very relevant topic and very important issue that's facing the community due to the pandemic. In general, eviction is a very stressful time for the tenants and the community, and there are far-reaching implications for evictions, more so than just someone losing their housing. There's a long-standing impact that transcends and that continues beyond the actual eviction. But for purposes of what I'm going to do today, I just wanted to give you a brief overview of the eviction process. This is going to be just a brief overview of most evictions. It's not going to cover each and every situation. And as Florise indicated, this is not designed to be legal advice. It's more so a general overview to give you a context of what the process is for eviction. So on the slide that you see, all evictions start with a notice. Landlords are not entitled to just summarily and arbitrarily decide to evict tenants. They have to start with a notice that gives the tenant the reasons why the landlord believes they're entitled to evict the tenant. What you see here on the slide is the process from notice. For non-payment of rent evictions, that will be a 7-day notice. That's called a demand for possession. It basically tells the tenant that your landlord believes that you owe X amount of rent or X amount of money to the landlord. You have 7 days to pay that or move, or the landlord can move to the next step for eviction. The other most common type of eviction is a termination of tenancy. That starts with a 30-day notice to quit. It's called a notice to quit. In that notice should be information for the tenant indicating the reason why the landlord believes that they're entitled to proceed with eviction. In some cases, it's a breach of the lease. In other cases, it may be simply that the tenant, the landlord wants the tenant to move. One of the common misconceptions for tenants is that as long as you haven't violated your lease or caused any problem, as long as you haven't, let me rephrase that. If you're a month-to-month tenant, the landlord can just give you a notice to quit for 30 days, a 30-day notice to quit, without having necessarily a reason. They just want to terminate the tenancy. Most tenants believe that even though they're a 30-day month-to-month tenant, that there has to be some sort of violation they've created or caused in order for the landlord to evict, but that's not what the law indicates. Two other types of basic landlord-tenant evictions are health hazard injury to premises. That will require a 7-day notice. That can be easily cured if the tenant stops the injuring the premises, if they're conducting some sort of activity on the property that's injuring the premises. If they stop it within the 7 days, then that should stop the process. That's one way to avoid eviction. If it's a health hazard, the tenant has the opportunity within that 7 days to clean up the health hazard, or to stop it, or to fix whatever the issue is. There's another 24-hour notice for drug-related evictions, but I believe another speaker is going to talk a little bit more about that, so I won't go into that. But as the professor indicated, currently there is a moratorium, a nationwide moratorium on evictions, order in place from the CDC. It's until the end of December of this year. The tenant, in order to qualify under that, there are certain different stipulations the tenant has to certify and complete the affidavit, or sorry, the declaration, and then give it to the landlord. And that should invoke the protections under that particular moratorium. Those are the general steps in eviction. Did you want me to speak further, Professor, or did you want Judge Coleman to give some of the context for eviction as far as 36th District Court is concerned?
Professor, you have to unmute.
Let me put some context we want to go back to that original slide, I think, so that we can kind of stay within the sort of general area of trying to introduce the topic. And let me begin by introducing the Honorable Donald Coleman. Judge Coleman has served on the 36th District Court for the past 28 years, and he has been presiding over a wide range of criminal, civil, and property-related matters throughout his tenure. During the past 3 years, he has served exclusively as one of 3 and now one of 4 judges in the landlord-tenant division. Judge Coleman has served also in religious ministry for more than 30 years and is the founding pastor of New Breakthrough Church International, an inner-city community outreach ministry with a global ministry platform. He's also happily married and the father of 6. My, Judge, you are very busy, and we certainly appreciate you coming this evening to provide a perspective. And I think it might be helpful to kind of transition to both talk about from sort of an historical perspective, because we're very fortunate to have someone who has been doing this for quite a long time. And you are now witnessing this awful pandemic and recognizing how it's impacted us. I mean, what are you seeing? Are we seeing differences, changes? What can you share with us? We're all forgetting to unmute, I guess.
Wow, I was trying. I'm glad to be with everyone this evening, and thank you, Professor, and to all of the other panelists. I can't think of a more important topic than to talk about Detroit tenants' eviction rights during the pandemic and all of the issues that interface with that. And of course, we work on a limited time platform, and so we try to get out as much information as possible. Thank you, Michelle, for presenting, I think in a very cogent fashion, the information that gives an overview as to how it is that people get into court and what happens once they are in court. And I may touch on that just a little bit. The background to so much of this relates to what we think of as the Great Migration, where some 6 million people over a period of 60 years came into the northern cities. One of those favorite cities, particularly during the period, the 50s through the 70s, was the city of Detroit. And that was because Detroit had and has a significant housing stock. And it was after some of the laws were passed to try and address some of the discrimination issues and limitations that were put upon people being able to purchase homes and live in certain areas. There was a significant housing stock available to all people, and people of color in particular, as I'm talking about this evening. The challenge now that we face is that that market has become more and more depleted over time. There have been a lot of demolitions, et cetera, and so the Detroit housing market is somewhat significantly reduced to start out with. And then we have this issue where Detroit, the 36th District Court, is one of the busiest courts in the United States. And just to give by way of example, as it relates to landlord-tenant items, in 2019 we had more than 30,000, about 31,000 filings of landlord-tenant type cases in the city of Detroit. This was pre-pandemic. And of those 31,000 or so cases that were filed, we had something in the nature of a third of those cases that resulted in eviction. That is significant. That we would have that high of a rate of individuals actually losing their housing. And of course, we know that when we're addressing issues of housing, there is a cascade effect. If a person loses their housing or does not have housing, oftentimes their access to other resources are stymied by the fact that they don't have a place that they can call home. And indeed, if they lose their home location, oftentimes they are stymied because of the fact, again, that they don't have a place to live. So a third of those cases resulted in evictions. So that is something that has been and is being addressed by various resources, some of which are on this Zoom in this discussion. This year, we've had, because of the pandemic, we've had a filing of something in the nature of maybe 10,000, 11,000 cases. And that's because the court has been closed down, shut down for several periods. And even with the pandemic, and even with there being that number of cases, we have approximately a 25% rate of eviction going this year, even in the midst of a pandemic. And as the professor was saying earlier, that there is somewhere in the nature of 40 or 50% expectation of evictions, but for there being a moratorium, particularly in the circumstances where there's a significant economic decline, where people have lost their ability to actually pay because they've lost their job, et cetera, all of the things that are part of that cascade. The eviction in a normal year would be, I hate to call it normal, but in a normal year would be somewhere in the nature of 1/3 of the cases filed. So under the circumstances that we're dealing with, that number would be substantially more. And so it's important to be informed, and I think that this forum is critically important because we can talk about some of the, and I know that throughout the discussion there will be some talk about some of the resources that are available, and some of them have a time limit on them that are available nonetheless, that may be able to assist people who would otherwise face eviction. So much of what Michelle talked about was driven towards the cases where there is a substantial amount of help that is available, again, with a time limit on it. And those are cases that involve non-payment of rent. Those are cases where individuals have been, the argument is that individuals have been substantially affected by the pandemic and all of the effects of the pandemic, and have therefore not been able to pay. And so the non-payment cases are treated differently during this pandemic than the termination cases. Now, at some point, there was a moratorium that stopped any evictions without regard to whether they were non-payment or whether they were termination type actions. But there's been a parsing along the way that addresses where non-payment cases are being addressed a bit differently than termination actions in terms of strategies for keeping individuals into their property. And the last thing I say, because I know there are a number of other things that need to be covered, is that some of the success that we've been having is that some of the cases that where there were judgments on them involving termination, we've been able to, or when those cases have come before the court now, where individuals are being exposed to lawyers that can assist them, some of those cases are being recast as non-payment matters, and landowners are being able to tap some of the available resources, and individuals are able to stay in their home because of the recasting of those matters. So there are some strategies that when all of the parties come to the table, that we have been able to employ with the help of so many who are on the Zoom and others, that we've been able to prevent evictions. And obviously that's one of the critical issues involved in this challenge.
Well, let me ask you very quickly before we bring on another veteran soldier who's been involved in this process, Ted Phillips. But Judge, one of the fundamental things that I think people might be wondering is why we restricted this to Detroit. Because at the end of the day, most lay people don't understand this concept of jurisdiction. So we're referring to today 36th District Court having jurisdiction over Detroit-based evictions, but aren't we within the state of Michigan? And why couldn't we talk about this across the board? If you would address the jurisdictional issues underlying this.
Yeah, you know, the same issues apply in so many other areas, and particularly people are brought closer together when there's a crisis. The pandemic will have a tendency to make other smaller areas look like major areas. Detroit, the 36th District Court is charged with having jurisdiction over or rulership over the city of Detroit. And so the only properties that come in front of me are properties that are within the corporate limits of the city of Detroit, because those are the only properties that I have the right to issue a ruling with respect to those real properties. So we're talking, of course, real estate that would have to be within the corporate limits of the city of Detroit. There are other judges.
But let me just cut to the chase because I've got to move on. But isn't it the case that obviously all of the courts across Michigan obviously are applying Michigan law?
Yes.
But within Detroit at 36th District Court, there are different court rules, right?
Yes.
How do
Yes.
you differ from these other areas? You're still applying Michigan law, but that's why we had to do it. I just wanted to clarify that because we thought at first about trying to cover the entire state, but there were too many differences and we were concerned about that.
And just very quickly, one of those differences was that our chief judge for a time extended the moratorium as a matter of local court authority. And while in other jurisdictions, once the moratorium was lifted in July, the first moratorium, a lot of other courts, they began opening the door for evictions. Our chief judge extended it for a period of time because, again, we have some local authority to be able to operate in that manner, although that local authority has some limitations on it, but we do have some local authority to operate in that way.
Very good, very good. Well, let me keep moving here because obviously we want to make sure that everyone has a basic understanding of the overview of this process. But let me now introduce Ted Phillips. I omitted him earlier, but Ted Phillips is just one of our warriors. That's all that I can say. He has been an attorney since 1983. I practiced with him back in the day at the Housing Commission. He was a staff attorney with Legal Aid and Defender Association from 1984 until 1985. He is now, he was the executive director for United Community Housing Coalition from 1986 until 1995. Now he's the general manager, program planning and budget. He's had so many titles, I'm just trying to figure it out. He was the general manager, program planning and budget director for the Detroit Housing Commission for 2 years, from 1995 until 1997. And then ultimately he expanded United Community Housing Coalition to provide legal representation in 36th District Court, to help with landlord tenant cases, to provide foreclosure prevention counseling, and to establish a low-income homebuyer program. He's a lifelong Detroiter, a proud technician from Cass Tech, and a Wayne State University Law School grad. Please join me in welcoming Ted Phillips.
Thank you, Florise. I was a bureaucrat for 2 years with you at the Detroit Housing Commission, and that was interrupting my 30-some-odd year career with UCHC. But I was more set to be a nonprofit director than bureaucrat. I would also just echo what the judge just said. Any district court could have done the progressive move that the 36th district did to extend the moratorium for another month, but Detroit was the only one who took that option. This part of what I was to talk about, I understand, was just a brief impact of evictions on households in the community. And I just want to make sure that we don't use words that are too polite here. When we're talking about eviction, we mean the bailiff coming out and evicting, okay? There's plenty more tenants who move out prior to that because they're afraid that will happen. And what an eviction means in Detroit is that a dumpster is delivered to the house. Everything in that property is put in the dumpster. The tenant not only loses all of their furniture, all their possessions, all their clothes that they can't throw in their car real quickly, but very often we have people losing medicine, losing their important paperwork, losing their family Bible, losing their history. This is a serious setback for everybody. So what happens to them when that happens? Some become homeless immediately. They go to the shelters. They check in with the CAM in the city of Detroit or whatever community they're in Detroit with the CAM. Most don't end up immediately in shelters. Many end up with family and friends. Many end up sometimes staying on the streets in their cars. and many end up in many of the abandoned buildings and structures in Detroit. The impact that that has, certainly when they're doubling up with family and friends, one of the things we see very often in subsidized housing evictions is one of the major reasons for termination of tenancies is having an unauthorized occupant in your home. What is that? That's a family member that, very often, a family member that had no place else to go. So it jeopardizes that family member's housing when that happens. And also in a situation where you have subsidized housing, senior housing, for example, bringing in a family with 3 or 4 kids or what have you, certainly jeopardizes during the COVID epidemic everyone that's living there. So it's everyone is hurt in that regards as well. Moving into vacant homes is certainly a problem in Detroit, but having vacant homes, the landlords having to pay for the eviction, then having a vacant home very often leads to stripping. And one of the clear evidence of that is that many landlords will even go to the extreme of going into their property after the eviction's taken place, removing the furnace and the hot water heater so that it's not gone. And when we find housing for our clients to move to, very often it'll be, we'll inspect it and discover there's no furnace there. And the landlord says, well, yeah, I didn't want to lose it. And that, it makes sense. Of course, they have to put it in before the client moves in. So all of those things are part of what an eviction is. And what is, as Michelle alluded to earlier, there's also long-standing effects. If you're evicted, that's on your record, that's going to be something that follows you. If you left in subsidized housing, that could bar you for potentially for life in housing. There's exceptions that could be made to that, but as a practical matter, being able to find housing that's available, it can bar you for life. I had a case just the other day, a call from someone who was homeless, who owed $515 from being evicted from Cornerstone Estates, which is right around the corner from us, subsidized housing. And they now can't get a voucher because they still owe $515. So we're trying to work that out. But these things have long-standing effects. So I just want to briefly just be real clear on what an eviction means. And one of the other stats from the court that I think is really important, the judge said 31,000 and about a third ending up in bailiff evictions. The other stat that's shocking is that in past years, the tenant representation has been about 4 to 5%. And that's not because there aren't aggressive advocates trying to do what we can. Legal Aid and Defender, United Community Housing Coalition, Michigan Legal Services, Lakeshore Legal Aid, and others, but those are the primary ones. But there just isn't enough funding to be able to go beyond that. And we're going to talk a little bit later about some of the changes in that area, I think. And hopefully with the court, we can get to the point where there's more complete representation for more individuals. But that's all I was going to cover at this point, Florise, I think.
Well,
unless you had
it goes
something else.
without saying that, if you will, Ted has made the case for why we're here this evening. This is a very serious issue. And as I said at the very beginning, this panel understands that as reflected by what they do. Now, in connection with this process of talking about evictions, we also wanted to look at this from a different perspective, because this is being done for Detroit tenants who are at risk. We also wanted to give them an opportunity to peek into the door, if you will, the landlord's door. What's sort of the perspective there? And so 2 of our young lawyers are going to give a quick overview of some of the documents that get filed and the like. And we're going to look at this for a minute from the landlord's perspective, because again, we want to cover 360 degrees this evening. So Attorney Potts, if you would go ahead. I think that Angela was going to speak first. Attorney Baldwin, is that correct?
That's correct.
All right, well, good evening.
All
So
right.
we want to begin by, again, introducing you. Attorney Baldwin is a civil litigation and transactional attorney for the Miller Law Firm, where her practice focuses on a unique skill set at the intersection of law, business, and government. Her practice involves complex business litigation, public contracting, among other things. Attorney Baldwin is absolutely deeply committed to civil engagement and quality of life for her community, as evidenced by her appointments by the Governor of Michigan to the Hispanic Latino Commission and by Mayor Duggan to the Elected Officials Compensation Commission. She is a proud graduate of the Detroit Regional Chamber of Commerce's Leadership Detroit class. She's also active with the State Bar of Michigan. The Detroit Bar Association has recognized her as one to watch, and she was featured by Michigan State University Law School's Spartan Lawyer publication in 2018. We are very proud of our young lawyers, and they want to bring a different perspective. So tell us a little about the landlord, just to give us a peek into that universe.
Thank you so much, Professor. What I would like to start off with is getting a better understanding as far as what are the landlord's options as far as rent is concerned and as far as receiving payments for rent. Michigan has rolled out something called the EDP program, and I understand we're probably going to have another speaker touch in detail about this, but from a landlord's perspective, this is designed to keep Michigan residents who fell behind in their rent during COVID in their homes, which is so important. What does that mean for our landlords? Well, by participating in this program, it will guarantee that the landlords get a substantial payment for back rent. That can be up to 90% of the tenant's back rent paid in a lump sum. The landlords are required to forgive late fees up to 10% of the back rent. That is a requirement of the program. Now, in order for a landlord to partake in this program, they need to initiate the process. And they do that by emailing MSHDA of their interest in applying. MSHDA is the Michigan State Housing Development Authority. They email that entity, and they include the property name, the address, the number of tenants that will be included in the application. Then MSHDA will email a link in a form to the landlord and use that to secure the application folder. The landlord uploads this application, and then the parties exchange information accordingly. Now, the landlords should be giving the tenants a copy of this application as well as the program information flyer, and they should work with their tenants to collect all the necessary documents that are needed for this application and complete it in submitting it over to MSHDA. So what that means is that the landlord is required to have a notice to quit, which I'll discuss momentarily, a demand for possession, a court order, a summons or complaint if they've taken it to court, a most recent copy of the lease and rental agreement, as well as a W-9 form. Any rental payments, histories that you keep, that should definitely be included. And if the landlord is an incorporated business, then you have to be represented by an attorney. So when landlords and tenants agree to go through this program, which is an amazing program, the parties will either enter into a settlement agreement if the case has not been filed in court. And the settlement agreement is a written document that is an agreement between the landlord and the tenant outlining the terms and agreed upon conditions between each party. If this has not, or if this actually has been taken to court, then the parties will enter and file a conditional dismissal. And that's where you would ask the judge to dismiss the case, but it also allows the judge to reopen the case and enter a judgment later on if certain parties don't follow the agreement. And Attorney Coleman Potts will be discussing more detail on that. So what happens if you've got this great program and that still is not working for some reason? Well, then that's when we get back to the summary proceedings, which we've already touched upon earlier today. This is also known as your eviction proceedings. And Mr. Ted Phillips did an amazing job in explaining the details behind what that really means. Going a little bit further and just kind of going a little in further depth, this process, summary proceeding, starts usually with a notice to quit or a demand for possession. But today, for simplicity purposes, we can just call that an eviction notice. Now, it's important to know that if a landlord is successful in proving their case, only a court officer may remove the tenant and the tenant's personal items from the rental property. A landlord must never forcibly remove a tenant's occupant, him or herself, and this is pursuant to MCL 600.5711. So that also includes things like changing your locks, turning off the utilities, or other acts or omissions that interfere with the tenant's right to use and enjoy the property. Why is proper notice so important? Well, it's important because a court will enter a landlord's request for an order or eviction, but that only will happen if proper notice has been given. And this is not only a due process right, it's intended to protect individual rights. So it's definitely something that should be abided by 100% of the time. Many times rental problems can be fixed if you just give an eviction notice and then just work things out with your tenant. Then it gets their attention and they understand the severity of the issue. As far as forms go, I'm going to defer to Coleman Potts on that. He's going to go over the specific forms, Attorney Potts, but I will say that your notice must be in writing, and it has to explicitly state that the landlord intends to evict the tenant, and that has to be within a specified time frame. And Attorney Johnson actually touched upon that. We have either a 24-hour notice, a 7-day notice, or a 30-day notice. Your 24-hour notice is going to be getting you to the court as quickly as possible. That tends to be for situations such as illegal drug activity or a formal police report that has been filed. Your 7-day notice, that's more for non-payment of rent, a serious or a health hazard, injury, or threat to another person or property. And then you get to your 30-day notice, which tends to be a violation of the lease, whether you have forceful entry or peaceful entry or trespass. Holding over is another reason. And then just cause, you've got terminating a tenant for, it could either be mobile home park or a government subsidy. Those would all fall under a 30-day notice category. Your next step in this process would be taking the action to court, and I will pass that along to Attorney Coleman Potts to go into further detail.
Thanks, Angela. We have lawyers on both sides, I'm sure. As a part of this forum tonight, we have those who are working to help tenants out. We also have lawyers involved who are representing landlords. And if your clients have anything like mine, they may be frustrated with the current process of evictions. Getting court dates may be taking longer. Filing the case may even be taking longer, but what they have to do right now is just trust the process. The Supreme Court of Michigan has put out a lot of executive orders, a lot of new Supreme Court administration orders, giving plaintiffs and pro se litigants direction on how to proceed with filing cases. So when filing your case, after your notice to quit has expired, if you weren't able to resolve the matter prior to actually going to court and getting a summons and complaint, you do have to now, when you're filing your case, file a DC 511. The DC 511 form, if I can bring it up. The DC 511 form is just a verification form that you have to file with all your landlord-tenant cases now, which provides a verification regarding CDC eviction moratorium declaration. I'm not going to go into the form in detail, but this is something that has to be filed with the summons and complaint prior to the filing of your eviction if you want it to be accepted. Once you finally get a court date, some of the other things that have changed that normally in the past, if you were to serve the defendant by attachment and they didn't appear for court, they may suffer a default judgment. However, now if you were not able to get personal service the first time around when you served your client, more than likely the court is going to adjourn your matter until you either serve them by attachment again or you obtain personal service. Once you do finally get your case in front of the court, that's when what Angela spoke about earlier, the eviction diversion program is available again. If your client does owe back rent, the eviction diversion program is there to possibly provide the landlord with funds for the what the tenant is back due. If you are able to resolve it with the eviction diversion program, or if the tenant simply just wants to move out of the property, they can sign what's called a conditional dismissal. The conditional dismissal keeps the eviction from being placed on their record. Unlike in the past, tenants more than likely would sign what's called a consent judgment. With the consent judgment, they could abide by the consent, and if they were to do comply with all the terms of the consent judgment, either they would be able to stay in the property or we give the landlord an opportunity to evict them. But with this conditional dismissal under DC 508, that at least gives the party the opportunity to keep a clean eviction record, which Ted Phillips spoke about earlier, could hinder you in the future. I did want to speak a little bit about post-litigation as well. Sometimes parties do enter into the DC 508 form, the conditional dismissal, but sometimes the tenants don't abide by that, the terms of the dismissal. In that case, there's a DC 509 form. That form is the order for reinstatement of the case and entry of judgment. In the past, before the coronavirus, most attorneys will have to file a motion to either reinstate the case or set aside the dismissal in order to get the case back in front of the court. Here we have an order for reinstatement of the case and entry of judgment, which would allow the court to move forward with the eviction. In addition to that, we have the DC 107A, which is the actual order of eviction form is if it comes to the point of eviction. So while all parties right now are working together to try to avoid evictions altogether, I just wanted everyone to be aware of the new forms and the process that has been taking place.
Well, thank you very much, Attorney Potts. I didn't have an opportunity to introduce you, so I will do it after your presentation. But Attorney Potts is a trial attorney with the Detroit Legal Group, PLLC, in downtown Detroit. He has practiced landlord-tenant law since being barred in 2014, along with criminal law and personal injury matters. And he is currently the Secretary of the Executive Council for the State Bar of Michigan, Young Lawyers section. So thank you so much. So before we leave this section, and you see there's so much to talk about, we can't get beyond the basic overview because there's so much. I just wondered if any one of the panelists who already spoke wanted to wrap up. I don't know, Ted, if you want to add something or wrap up, and we can move forward to our next section. And Mr. Potts would put up the flyer again so we can keep everybody in tune. That's the academic in me. I like to make sure that everybody knows where we are, I guess. But if you would put that up. But Ted, do you have any additional comments, or, you know, are we able to sort of conclude and talk about some of the specific things that this pandemic has brought us? I think we've integrated it, but does anyone want to add anything else to that? Ted?
Done. Oh, there we go. I was having trouble unmuting.
Okay.
Just to add that the process that was said for the eviction diversion program, that is what is for bulk filings by landlords. There also is a process for tenants. I don't know whether we want to talk about that later or not, but tenants can apply directly and landlords can apply directly. And also that MSHDA process, we're told, and I think they've actually posted something on their website, that as of December the 11th, they're going to let landlords know that they cannot guarantee that they can process the applications before the end of the year, because these funds must be committed by December the 30th. I use that word because that isn't the same as checks have to be written and out the door. There is some possibility for some work up until February 15th, but they have to be committed by that time. So, so that is just one little modification. So.
Okay. Well, again, I wanted to make sure that everyone is tracking what we're doing, and this is such an important topic until we've got too much to discuss and perhaps not enough time, so we'll do the best we can. But the next topic ultimately is to talk about lawyers on the front line. And we've got some lawyers who are here on the front line. We heard from the young lawyers who are representing, Mr. Potts is often representing landlords and tenants. But I use this term front line very loosely because we know with this pandemic, the people that are really on the front line are our healthcare workers. And we all know that, we respect them, and we are so grateful that they are protecting all of us. But it seemed to me that in this context, we also have lawyers who are on the front line, who are in court, not in person, but online. So could someone please help me with those dynamics? I think, Ted, you were going to talk about, you know, sort of creating a picture for what it looks like post-pandemic or at, you know, during the pandemic. I wish it was post-pandemic. You know, what does it look like? Who's on the front line? Who's helping you and Michelle in court? How does that work?
So what we have collectively been trying to do, all of the legal services organizations, is to be in every courtroom every day. And one of the things with the cases coming back beginning in August, when the court reopened, was that there were fewer cases than we've seen before. In past times, there's been as many as 200 or so cases a day, and Judge Coleman might correct me on that, it may be even more than that. So there have been fewer cases, so there has been the ability to have a couple of attorneys, some law students in every courtroom virtually, so when cases came up, the court could ask, the judge could ask the defendant if they would like counsel, and then they could go off in a side room and talk and at least have a chance to get some representation and into the eviction diversion program if that was appropriate for them. One of the issues that we've all seen is that because of the situation with the post office, to be polite, there was a lot of problems initially and probably still with notices to individuals, mailed notices, particularly to individuals. And one of the things that we noted at the Housing Coalition in trying to do outreach before the court opened up is that many of the initial cases that were being brought before the court, no one knew they were coming before the court. When we called opposing counsels to say, we would like to work something out, we were the ones giving them notice of the fact that they had a court hearing. So this was brought to the court's attention, and many of those early cases had to be adjourned, new notices sent out and what have you. And we also worked an arrangement with the city of Detroit for the Department of Neighborhoods to do some door knocking, which is not perfect, but it did give people notice of their cases, at least in many situations. Sometimes that ended up being a flyer left on their door, or a letter rather that I wrote left on their doorstep, but it did result in many more people coming into court. So various kinds of ways that advocates have worked. In court, I think what is important to note is that most cases do settle, and once there's lawyers on both sides, there's certainly a better chance of that happening. And the settlements that happen are why there's fewer evictions, many fewer evictions when there's attorneys involved. As the judge said earlier, about 1/3 of the cases in past history have ended up being bailiff evictions. But in our experience, when someone is represented, that's maybe 1% to 2% at the most. And usually those are cases that are taken very, very, very late in the process. And even then there's very small chance. And the reason for that is that usually when someone has an attorney, there's a negotiation done where at least, if nothing else, there's generally time being able to be obtained for the person to move out. It's in the landlord's interest to give a few extra days or a week or so, rather than paying a bailiff money to set the person out. Sometimes there's payment plans that can be worked out. There's repairs. There's sometimes an issue that can be resolved. And worst comes to worst, in many situations with subsidized housing, where the landlord just doesn't want to deal with subsidized housing anymore, perhaps, and it's questionable whether the tenant has a defense or not. Very often there will be what's called a voluntary move. And what that means is that the parties will agree that the tenant has not violated the lease. The tenant will agree that the landlord hasn't violated anything, and the parties will amicably agree that they will part their ways. And the significance of that is that a family that might otherwise lose its subsidy, and in some cases these subsidies amount to people paying $150, $200 a month rent. No place else could they rent for something like that. Being able to keep that with the voluntary move, as opposed to the judge making a finding that they had violated their lease in some fashion. And again, that violation may be something as simple as they took their son or daughter in who was on the street. And yes, that's wrong, but that's what all of us do as parents. It's just we don't live in subsidized housing, and that becomes a problem. The other thing that we have very often in these cases, in terms of settlements, is that the conditional dismissal concept is sort of, the forms are new, the concept's not. We have for years negotiated consent agreements, which the final line would always be on the one, not always, but on most of the ones I did, would be that if the terms are complied with, the parties agree that this matter will be dismissed. And that would be the final record that would be with the court. And again, as we said a few times, that has enormous significance in terms of being able to move forward for the person. So it's not a matter of necessarily of everything being litigated, although there certainly are cases that are litigated. There's differences of opinions, and that's why judges were created, right, Judge?
Well, let me just ask something a bit more specific, because I want to make sure we stay on task.
Yeah.
And to the extent that we're talking about lawyers who are on the front line, I want to hear about the specific lawyers that are showing up on Zoom or whatever platform the court uses. I really want people to have a flavor for what's going on, because typically everyone was able to go down to the courthouse, but now the judges are online, right, Judge? And so I literally want us to give people this sort of vision of how this works. You get a notice. We've talked enough about that. And then in turn, what do? You get a Zoom link, or you get a link to your particular time. And, how does this work? I want people to really feel, and hopefully they won't have to experience it, but we may have people on here who don't have access to the internet. We've got to talk about this from a very practical perspective, because here we have a list of all of the organizations that are taking lawyers and law students down, and we're going to talk about how people can get involved in a minute. But really, Michelle, how does this work? How's it being set up? Uh-oh, got to get you unmuted there.
Okay, well, when the court sends out the notice includes the Zoom information. It'll indicate on the notice that it's going to be a Zoom hearing. And it gives the information on how to connect to the Zoom hearing for the tenant. and what their rights are. So it's been very interesting to watch the process. I know that there are a lot of tenants who are not technology savvy or comfortable with Zoom. So there is a phone number, a call-in phone number as well. And they can also always contact the courtroom directly if they're having any kind of technology issues. The court's been very, very responsive and very concerned about making sure that everybody has an opportunity to appear in court and to have their side heard and their case adjudicated.
So
Yes.
what if the family doesn't have access to the internet? Are they going to the libraries, but the libraries aren't open? I mean, so
Well,
what if
they don't need internet. They can do, there's a call-in phone number. They can call in by phone. They don't have to specifically
can
do
call
Zoom.
in?
Yes.
All right. So
Yes,
we
it
can
includes
call in
Zoom.
because you get the link or there's a phone number on there. So
Yeah,
you can
exactly.
make arrangements. So the other part
Yes.
of this, the other side of this is that, can someone kind of walk me through this list? These are the organizations that are providing the lawyers, but aren't some of the law schools also sending law students to the virtual space? Because I can't say to the courthouse, so can someone walk through these groups and, let's celebrate them, because these are the lawyers on the front line right here.
Well, we certainly had students from UD and Mercy Law School from my housing clinic class that were there. And we had a large number of volunteers from U of M. I think there was 60 students altogether as part of a COVID collaborative, they called it, I think, that spent some time in court as well. But certainly attorneys from all of the organizations, the 4 main organizations, have been there on one or another in every courtroom every day. Now, I will say that imagine you're meeting your client for the first time in court, and all you have is them on the phone. So, I mean, there is that challenge, and even if it's in person, if it's virtual, I mean, even that is a bit of a challenge as well. So you have people sometimes that are a little bit upset, and it's, if you're in court with them, you take them in the hallway and have a conversation. That doesn't happen as easily in that kind of a setting.
That's right, because of course we have a responsibility to protect that attorney-client exchange. So how is that happening virtually? What are we doing?
Well, there is a side room, and Judge and perhaps could explain that better, how that's done.
Yeah, we have on the Zoom platform, which is basically what we use. It provides opportunities for to place individuals into a breakout room. The host can control that. In those rooms, they have the opportunity to talk with individuals on a private basis. I think that one of the big issues, one of the big negative issues here that we've been challenged with is some of the technology issues, but I think that everybody has been finding ways to work around that. One of the incredible issues that has become a part of this reality that makes things kind of come together is if you look at what's commonly referred to as the Summary Proceedings Act, the act that covers landlord-tenant proceedings across the state of Michigan. The ideal there is acceleration. It is a 7-day notice, and then within 7 days you're in. After that notice, you're in court. A 30-day notice. A short time after that, you're in the courtroom. And you could very well end up with a 7-day notice. Then 7 days later, you're in a courtroom, and a hearing be conducted that will give you 10 days to move. And if you don't move, then a writ could issue after that. The Summary Proceedings Act is summary. It's designed to move things along quickly. One of the benefits, one of the benefits that have been urged from this pandemic kind of situation is that we've been able to look at what happens in a landlord-tenant setting when you don't have to abide by those accelerated rules, and when we can slow things down, number one. And number two, when you are able to integrate resources. And the really big thing here has been that those two factors, that we've been able to slow down the entire process, number one, and then number two, that we've been able to integrate resources. So, for example, one of the things that Ted Phillips did not mention is that even at the end of the line, oftentimes, Michelle Johnson will know this as well, where a person is going to move out at a certain date, they've got to go, that oftentimes there is a process for connecting them to alternative housing. But all of that is brought into the Zoom setting because of the fact that all of the resources are right there. And I pretty much insist on every person that comes into my courtroom, in the Zoom courtroom, and when they come in, I kind of cajole them and encourage them as best as I can to talk with a lawyer. Why? Because there are lawyers available. Lawyers and law students that are practicing on this the special rule that allows them to practice, et cetera. This gives that resource to the being available to the court, and of course to the tenants, as well as I regard it as a resource being available even to the landlords and their lawyers. That is to have all of the resources right there being integrated so that we can take a look at what should we do in this individual case, in this package of cases. And we can look at it from the standpoint that we have resources here that can be integrated, and we can think about how we might want to move forward. Of course, having the pot of gold, the EDP program, that does not hurt either. But Ted Phillips, Mr. Phillips was talking about earlier that one of the big challenges to being able to address issues of housing. Let's not even talk about eviction. And thank you, Ms. Baldwin, because she pointed out, as well as Mr. Phillip, about this whole thing about eviction is about, people being put out of their house, and that being the end of the road for them. But one of the important things that we get to think about here is that we can connect resources, we can connect people with lawyers to talk to, and that will decrease the number of people that become homeless,
Right.
the number of people that...
And Judge, that's a good segue for me asking the ultimate question. We have a list of the, if you will, lawyers on the front line. We know that some of the law schools are involved. So I guess what I want to know, because for people that are listening, and of course we're going to make sure that we put this forum out into the universe, do we need more help? We're going to talk about what we can look forward to, unfortunately, at the end of the year, once the CDC moratorium is over. But how are we going to manage that? I don't want anyone to answer, because I think we've got to get to that. But we've got to create a way to make sure that we have as much participation as possible. So I'm going to ask Ted Phillips and Michelle Johnson to think about that, but I've got to move on because time is, of course, clicking away. So why don't we move on to talk about our next section, and then I'll invite some discussion. But I was going to talk about strategies to avoid eviction, which is really just a quick, make sure you remember this for tenants. And so if Mr. Potts, Attorney Potts, would pull that up, and I will quickly walk through that, but I trust everyone saw those names. And if we can get to those slides, I'll go through it very, very quickly so that we can, get to questions, hopefully. But I wanted to try and make sure, I guess I can control this, I hope so. If you would keep clicking. I wanted to just talk briefly about two specific situations, because I really, and I think the panel might agree, we wanted this to be strategic. And so, of course, everyone is talking about all of these topics. I wanted to kind of cut to the chase. If you and or a loved one have received a notice, if you and or a loved one predict that one is coming soon, I just have some things that really sort of bring everything together that we've talked about and have created a list, or attempted to. Mr. Potts, can I control that or no? Next slide, please. Obviously, the first thing to do is to try and get assistance from the resources we will be providing you with, and check for more. We're going to provide in this next segment a list of resources. You already know that obviously when you get to court, that there are people waiting on the sidelines in the virtual space, okay? So to the extent that we are not endorsing any of the organizations that we've indicated in our slides, however, these are just broad comments. You should always do your due diligence or confirm that the individual or organization is well respected, within the community. And how do we do that? Well, for individuals, make sure that you contact the state bar to confirm that the individual is a licensed attorney in good standing. For organizations, it's also possible if they have a particular type of license, it's crucial to do your due diligence. To prepare for all of your meetings, right? To prepare, always take all of your documents, right? The lease, notices, receipts, hearing notices, so that it's always imperative to have everything that you need related to this case. And it may seem like some of this stuff is obvious, but it's important just to keep it in mind, right? Now, as it turns out, and as I understand what our panel said, we have lawyers on the sidelines, but I simply wanted everyone to be familiar with the concept of pro se, that in some scenarios, people are appearing and perhaps they say they don't want a lawyer. But under these circumstances and for a time such as this, we have resources, and make sure that you are taking advantage of those resources so that your rights aren't in jeopardy. Okay? Now, if you have not received a notice, but predict that it will be coming, obviously the first step, again, is to contact the resources that we will be providing at the end. However, again, I've got a quick little list. Sit down, and of course, one of the issues that we have that is a major part of this scenario is unemployment and lack of employment and underemployment. And so by mentioning this, it could very well be that there is no budget, and we are aware of that. At the same time, as our panel said, often during these hearings, people are negotiating. And so it still means that you need to sit down and look at what you can do and look at that realistically. And often, given the economic circumstances that we're in, it may mean that there are no options. But pull out your lease, right? And take a look at that. Make sure, because I'm a firm believer, even though I teach law students, that people need to try and become familiar with their documents. You become a better client when you are at least familiar and have read your documents in advance. Okay? Now, a lot of times people will try and enter into their own agreements. I just wanted to give a quick little expose on that. It's very important to first contact an attorney or to wait to see if you can get some assistance. But if you believe that you can negotiate with your landlord, it's very important that you take a look at the language. Now, there may be some scenarios here where there is no lease, there is no written lease. But in any event, if there is, it's very important to take a look at it. But here tonight, we're encouraging you to take advantage of the resources. So if you believe that you can negotiate, you want to get that proposal to the landlord by mail, return receipt, and of course there are ways in which you can impact that lease, but for a time such as this, try to find a lawyer to help because there are so many things at stake. But I simply wanted people to be familiar with exactly what their options are. Thank you very much. Now, getting back to our topics, I just wanted to provide that brief overview. And if you would give us one other opportunity to see where we are on our flyer here as we try to keep up with all the things that we wanted to discuss. We now are under the prevention and help umbrella, and we want to talk about some of those resources that I kept referring to. So we now want to take a look at some of the options that are available. We, of course, as a panel, took the time to actually try and identify exactly what's available. And you know, at the end of the day, this is not the complete list. And if anyone is aware of any other resources, please contact us so that we can make it a part of what we distribute as part of what we're doing. But for now, if I could get one of the panelists to kind of walk us through these, that would be very, very helpful. I don't know, Michelle or Ted, you guys are obviously interfacing with these groups all the time. Can you give us a quick overview?
Well, certainly the top one there is the call to make for the eviction diversion program help. That's Wayne Metro. And if you've received it in your Detroit, Hamtramck, or Highland Park, and you've received a demand for possession, they would take the case and work with it. If it's a case in court, they would be referring it to us. Legal Aid and Defender, of course, is Michelle's group, and United Community Housing Coalition is mine. Both of us provide attorneys for court. The one area that I missed that Judge Coleman mentioned, actually, we also provide relocation assistance too. So I missed my own program there.
What is relocation assistance?
Helping to find housing, cover first month's rent, inspect the housing, make sure it's decent and affordable and is owned by the person that's renting it, things like that. And we've been doing that for many years. There's some restrictions on it based upon income and what have you, but we do provide that service if you qualify for it. Wayne Metro is currently also engaging in providing help in Detroit, Hamtramck, and Highland Park in support of us. They're doing all the eviction diversion cases that have just a demand for possession. They also cover the entire Out County area in Wayne as well. They also have a number of other programs dealing, I don't know all of them, but dealing with utility assistance and various other kinds of issues as well. In the Department of Human Services, their main support is state emergency, in terms of housing, is state emergency relief. That's not a huge amount, and it has to resolve the problem. So there's not a lot of the clients in the eviction diversion that are able to access that, the ones that owe more than eviction diversion can pay. And I should note that we said earlier that, I may be wrong, but we said earlier that 90% of the rent was paid, but that is capped. And for the lowest income individuals, 50% or lower of the area median income, that's capped at $3,500, which is very generous compared to past programs. And for persons with a higher income, up to 100% of the area median, they can get $3,000, and they have to pay, but they're required to make a copayment of various amounts. So it is a very generous program, but it isn't doesn't cover everybody's entire rent. Those are the basic ones that are available. There's occasionally other resources. We've had, and I think actually Legal Aid Defender has as well, emergency solutions grant funding and some block grant funding. Michelle, do you want to talk about that since I ran my mouth?
Thanks, Ted. We do have some funding for eviction prevention assistance, for rent assistance. It is through the City of Detroit, the Emergency Solutions Grant. The basic threshold is 30% of area median income. It's very low income. It's a small amount, but it really would be helpful for those who are subsidized housing or only owe a little bit towards rent, in terms of back rent. And it basically kicks in when you're at the stage when you have an eviction judgment. So to the extent that someone just has a notice to quit at this point and it hasn't gotten to court, the Detroit Eviction Help, the EDP Eviction Diversion Program, really is the best option to get assistance as quickly as possible, because it doesn't put the tenant in jeopardy of eviction judgment. And we've already talked about the various ramifications of having an eviction judgment and its impact on subsidized housing, and generally its impact on any housing when a future landlord can look you up on the court's docket and see that you've had an eviction case. So
or check your credit report. Right.
Exactly.
Right.
So the sooner, I agree with, the sooner we seek out someone tries to get some assistance, the better. So the EDP program right now, with the amount that they can pay towards assistance, is really a good, it's really good project.
Okay, well, we also received some information from Wayne County, and it's specific information though. And of course, we always salute members of the armed services, and Wayne County has special resources for those veterans. And so this is a tremendous opportunity as well. And I encourage those of you who were honorably discharged wartime and peacetime veterans residing in Wayne County. This is a tremendous opportunity. And Wayne County Executive Evans was very interested in making sure that people were aware of this, because they are virtually providing access to the very resources or the very, things that are concerning people right now, and providing resources. So this is also something that people should know about. And what we're hoping, of course, is that you will take this information and share it. At the end of the day, we're going to find ways to get it to churches and community groups and the like. But it's very important for us to get as much information out. And one of the things is, when you turn on the television, we hear all of these awful statistics, but we need to talk about solutions and how we can help people to deal with those things. And that's what we've been trying to do this evening. So let's go to our final segment. Believe it or not, time has gone by very quickly. And, here we are almost at the end of the year. The CDC's moratorium is about to end. What are we predicting? First, with respect to the need, again, for more lawyers to assist, because aren't we expecting some tremendous challenges after the end of the year?
Well, my hope is that the pandemic and the response to the pandemic becomes a sort of a case study of things that can be done that we never thought to do, or never put together the resources to do until faced with a crisis. I think that much of what is being done right now needs to be the regular order of business. Although the volume of cases will increase geometrically, it's just that there's a floodgate that's waiting to open. But that even that floodgate begs for a system that makes lawyers available, that makes individuals available, that can be a bridge between landlords and tenants, and that can be an amicus, if you will, to the court, that can help bridge together a resolution on one of the most critical issues that we face in our lifetime, and that is the issue of housing. And so the pandemic has been an absolutely horrendous thing, but this coming together of resources and connecting people together to prevent eviction and to give folks a chance to get their footing, and lawyers being able to do darn good work and leave away from it feeling good about it. I can see that. I can see that on both sides of the equation.
Right.
This is something that is working. So if this can become a laboratory that these things will not be dropped after the pandemic, would be an incredible sea change for how we deal with issues of eviction going forward.
Well, Ms. Baldwin, what do you think? You've been quiet since you spoke. What are you predicting?
She's still muted.
Yes. I think the host needs to, okay.
There we are.
I think that right now it's such a interesting time. It's a tough time, especially for our tenants here and for those trying to make ends meet. I think the great thing is that we've got tons of resources available to them, which is absolutely amazing. I think the biggest push is to get the information out there so that way people have access and they understand what their next steps are, who they can reach out to. I mean, we've got our contact information here, so people are free to reach out to us directly. The slides will be available so people can click on the links directly, but ultimately what it is going to be is pushing out the information. I mean, we've got $60 million that has been set aside in the coronavirus relief fund. 50 million of that was set aside to help tenants and landlords resolve these eviction filings. So it's just a matter of getting the information out and making sure people have access to the resources that are available.
Mr. Potts, do we have any questions yet?
Yes, we do. And thank you for coming back to me on that. I do have a question. First question and anyone on the panel can chime in on this. For solo practitioners interested in social justice law, what are some things that students can do now to prepare them to impact their world?
Wow, that's loaded up. That's like 10 questions in one.
But I'm so proud of whoever asked it. That's a great question.
I think that if you're talking about what can lawyers do in this regard to prepare for a social justice response. Well, I think that the housing issue is an issue that is one that everybody can relate to, and there are so many social justice issues that interface with the issue of housing, and to the extent that persons want to be involved in that regard, that they should connect with advocacy groups that relate to housing, because housing is a huge issue, and I think it's always been, but the pandemic has brought that to the forefront. And if there's an issue worth fighting on, the issue of housing is an issue worth fighting on.
And
We
so
use
how
volunteers.
how can they get involved? Mr.
We use
Potts?
volunteers all the time. So I
Yeah,
mean,
yeah.
in addition to the eviction crisis, come January, the other crisis will be the tax foreclosure crisis, because there's potentially 40,000 homes in Detroit that are in jeopardy of, as of when the petition was filed, that are in jeopardy of being lost April 1st. So
Now that's
we
our
will-
next topic. Do you promise to come back, Ted Phillips?
Oh, sure.
Michelle Johnson? Everybody, we've got to
Yeah.
keep
That's a
we've
biggie.
got to keep these talking drums working. We've got to. And to the person who asked that question, if you're in law school now, and if your law school is not involved, is it possible to get more law schools involved? Ted and Michelle?
Yes, absolutely.
I'm sure.
Absolutely.
So, you know, go to your deans, go to whoever sets up those programs. It's time to act right now. Time is of the essence.
And on the contacts information slide, there is information for our office and for UCHC on how to volunteer. So if you go to their volunteer@uchcdetroit.org email, or on our website, www.ladadetroit.org, there is a volunteer button at the top of the page.
Any more questions, Mr.?
Yes, I did get a question. What are the most common mistakes landlords make when it comes to evicting tenants? I can actually take the lead on that, since I do most representation for plaintiffs and landlords. I think the most common mistake they make is trying to do it themselves. Not going to the court, going to their tenant's house and maybe changing the locks, or after they send the notice to quit, acting as if that is the ruling document to get them out the property. Self-help is definitely the biggest mistake that landlords make. Another mistake that landlords make sometimes is that they file the case before the notice to quit expires. That does render your case invalid when you get to court. You do have to wait for the expiration of the notice to quit, whether it's a 30-day or a 7-day, but I would say the most common mistake is that they try to do it themselves. We do have another question. It's regarding the eviction diversion program. Who is eligible for the program?
I think we ran through that, but maybe we need to clarify one more time.
Yeah.
Yeah, Detroit residents are eligible. You want to take that, Ted?
Eligibility for EDP.
We got a question about clarifying eligibility for the
EDP?
program.
Yes.
Yes, so eligibility for EDP is you need to be a tenant, you need to have received at least a demand for possession. That's the notice for non-payment of rent. You need to be at an income no greater than 100% of the area median income, which is fairly high because I don't have it based on family size. The most benefit is for those households that are at an area income of 50% of area median income. That's fairly high because the area median income is based on the Tri-County area. And as we know, the incomes in Detroit tend to be much lower than that. Those are the basic requirements, but then the landlord also has to agree to participate. If he does not want to, he or she does not want to participate, they don't have to. There are documentation that has to be obtained, and that's where some of those sometimes slows things down. They have to provide verification, the tenant has to provide verification of income for the last month, pictured ID, basically proof of who's in the household, things of that nature, a copy of the lease if there is one. The landlord needs to provide a documentation for the ledger to show what rent's owed and things of that nature. For the lowest income population, we can give $3,500 plus pay 2 months rent going forward, capped at $1,200. For those over 50% of area median, the cap is $3,000, and they have a copay that's mandatory. Landlords do have to give up a percentage, which was said earlier, roughly 10%. That's not waivable. I've noticed that some cases have been entered, unfortunately, with the tenant paying that portion, but that's not waivable under the program. So landlords do have to give up that amount. As a practical matter, when we have cases where there's more owed, then the tenant can enter into a 12-month payment plan. Where that's not feasible, then we're going to look at moving the tenant, or there needs to be some other negotiation done with the landlord, frankly. For example, a SSI income is at about $780 a month. If with the monthly payment plus a payment plan on the arrearage, the person's going to be paying $900 a month, that's just not feasible. So we would look at moving somebody like that, or negotiating a different resolution.
Very good. Thank
Does
you.
that cover it quickly?
Covered it.
Yeah, thank you.
Very good.
Sorry,
Any
someone
more
was vacuuming when I jumped up. I'm in my office. So.
Any more questions, Attorney Potts?
I think we touched on resources, the program, and maybe this is a question with regards to I don't know if anyone can touch on this with regard to housing inspections. What is the best way to find out the latest on housing rental laws as they come out or change? Is there anyone who can touch on that?
I don't know about changing, but finding out whether there's been an inspection would be through the Building and Safety Department with the City of Detroit. I'm not sure how you go online and do that, but they are pretty open to responding to emails and phone calls. 224-BSED, 224-2733. Florence, I know you didn't want to give it out that way, but I didn't anticipate that question.
And it should be noted that whereas in the past, this has not been the case, but we're moving into a future that is like a now future where in order to bring your case, the landlord, in order to bring their case, they're going to have to attach a certificate of occupancy to show that the property has been inspected and meet the requirements for rental. So that has not been required in the past, and there's been a rolling inspections. And so we've been kind of slow to integrate the process, but we're right upon that day where you're going to have to, the landlord is going to have to attach the certificate of occupancy as a condition to filing the complaint.
Very good. All right. Well, have we come to the end, Mr. Potts, or do you have any other questions?
That is all. That is all we have for now. I just want to thank everyone who attended today. I want to thank all of our esteemed panelists for participating. The PowerPoints as well as this recorded program will be made available so that you have all of our contact information and all the information we shared today. And once again, just want to thank everyone for participating, thanking the Housing Gap podcast as well as the State Bar Michigan Young Lawyers section for presenting this program.
And thank you. Hopefully we were helpful.
Definitely.
For a time such as this. And thank you, panelists. It's been my pleasure. And again, we have a lot of work to do, and I hope these types of programs will become our new normal. Thank you again for joining us, and we look forward to seeing you, those of you who participated. We appreciate it on a Wednesday night. Take care, and we hope to see you soon.
Thank you.
Thank you.
Stay safe.
Yes, indeed.